Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning we have two dockets. We have an announcement docket and a motion to revoke probation docket. When I call your name, please come forward with your attorney. If your attorney is not here, we'll wait for your attorney to arrive. If your attorney may be in another court handling another matter. Now, if you are not represented by an attorney, or if you are representing yourself, then when I call your name, please come before the bench by yourself. First case is cause number 25CCCR 2324. Case is style of state of Texas versus Eduardo Chavarria. Chavarria, would you please come forward? Good morning, Mr. Chavarria. You have to stand in front of the bench. That's. How are you doing, Mr. Chavarria?
Good.
Good, that's good. Now, Mr. Chavarria, you're represented in your case by your attorney, Attorney Walter Windler. Attorney Windler, how are you doing?
I'm fine, Judge. Thank you.
That's good. State is represented in this case by Attorney Shane Hilton. And Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Mr. Windler, what is your announcement in Mr. Chavarria's case?
Your Honor, I'd like to request a reset. I'm in the process of trying to work out a deal for pretrial.
Okay, pretrial diversion?
Yes.
Yes, sir.
Okay.
There's a question as to, I've already looked into it and gotten a response, but I believe that there's a discrepancy in the records that Mr. Knauf has, and so that's what I'm working out with.
Okay, this is going to be reset in April, second week in April, because they have pretrial every other month.
Okay.
Okay, and so the next one after February is going to be April. Give us a reset. Okay, this case will be reset to April 13th of 2026. Mr. Chavarria, you're going to get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. Windler, you're free to go as well and you have a blessed day.
Thank you, Judge. You too.
You're welcome. Let's see who else this is. Next case is cause number 25CCCR 2340. Case is style of state of Texas versus Latoya Annette Elam. Miss
Yeah,
Elam
I'm here.
appearing via Zoom. Miss Elam,
Yes.
how are you doing?
I'm trying to get better. I got the flu.
Okay, we hope that you have a full and speedy recovery. Now,
Thank you.
Ms.
Thank you.
Elam, you're welcome. Now, Ms. Elam, your case was reset.
Okay.
Hold on a minute.
Oh,
The case was reset to give you time to hire an attorney.
yes, sir.
Have you hired your attorney?
No, sir. I need a little more time.
Okay. Give us a standard reset.
Mr. Wynn? I'll tell him to contact. I'm sorry, Judge, which document she wants?
She's on the announcement day.
Okay.
Yes. She's at the page 7.
Watch. We have.
What about I can be on a Monday, Wednesday, or Friday. I said Monday, Wednesday, or Friday.
We have a docket on the 27th, so we got 30 on the 25th. We don't have a docket on the 27th, so it's on Monday.
What's on the week before
The
that?
23rd?
Yes,
You say 30 days, you wanna put it on 23rd?
yes, that's good. Okay, we'll reset this to, what is that, February 23rd, 2026. Ms. Elam, your
Can I,
you'll be
yeah, go
given
ahead.
notice if you, what you said?
I was trying to see, I got a new job after I get well, and I wanted to see if it could be on a Friday because they strict. They don't want to you can't miss no days or they'll start writing you up. And the only day I have is Friday off.
What is the Friday before that?
The Friday before?
Yeah, hold on a minute.
That way I can still keep my job.
I understand. Be like the 18th, something like that.
Whatever be the 20th, Judge.
Okay, this case is reset to February 20th, 2026.
Okay.
Stay in contact with your bondsman.
Mhm.
Your bondsman will be given notice of your reset. You're
Okay.
free to go. And again, we're
Thank
praying that
you.
you have a full and speedy recovery.
Thank you, Your Honor.
Okay, you're excused and you have a blessed day.
Okay, you too.
Thank you.
Thank you.
The,
My phone is for
2, case of style of the state of Texas versus Jose J. Bernal. Mr. Bernal, is that your full name?
Yes, sir, it is.
How are you doing, Mr. Bernal?
Doing better, sir.
That's good. And Mr. Bernal, you're represented in your case by your attorney, Kristen Cawthon. Attorney Cawthon, how are you doing?
Doing well.
That's good. And Mr. Hilton, I have before me a motion to dismiss. Is that correct?
That is correct, Your Honor. We also have an agreement for a forfeiture of the weapon.
Okay. Okay. Mr. Bernal, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bernal, you may put your hand down. Now, Mr. Bernal, I have before me a motion to forfeit the weapon in cause number 25 CCC Aura 2422. Do you recognize this motion? And is this your signature on the line that's titled defendant?
It is, sir.
Now, before you signed and initialed this document, did your attorney go over this document with you?
It is, sir.
And did you understand everything that your attorney went over?
I do.
Is everything in this document, true and correct to the best of your knowledge?
It is, sir.
Mr. Bernal, I'm granting the motion to forfeit the weapon in this case to the Beaumont Police Department. And state, I have a motion to dismiss. Is that correct?
That is correct, Your Honor.
For forfeiture of the weapon in this case, and Mr. Bernal, I'm signing the motion to dismiss this case. Signing the order to dismiss this case.
Yeah.
Hey, Mr. Bernal, you can get a copy of this motion and order, the order to dismiss from our court coordinator. Once you get a copy, you're free to go and you have a blessed day.
Thank you, sir.
You're welcome. Let's see. Mr. Kelly, you have a case?
Yes, Judge, I do.
Oh, my God.
Motion.
Yes, who's the client?
Aaron Peets.
You have a keys,
Peace.
piece? You have a piece on the docket?
I wonder if we maybe weren't set up the same day, but we were just next door on the felonies.
Anything.
Give her your name, give him his name, and then we'll see.
Oh, yeah, three, okay.
Yes, Judge, thank you.
Yes.
That's weird. Okay. Oh, yeah, I think it was one of those yesterday.
Okay, Charles Jason Kramer, we have 5 cases. Cause numbers 25 CCCR 0594, cause number 25 CCCR 2266, cause number 25 CCCR 2265, cause number 25 CCCR 2264, and cause number M333072.
You know.
And Mr. Kramer, how are you doing?
Yes, sir, I'm doing all right.
That's good. And Mr. Kramer, I think the last time that you were here, well, first of all, Mr. Kramer, you are representing yourself, is that correct?
Yes, sir.
Okay. Now, the last time you was here, I think you was scheduling an appointment with the district attorney's office to get discovery in your cases, is that correct?
Yes, sir.
Okay. Now, were you able to visit with the district attorney's office?
No, sir, I didn't get a chance to. Had a lot of stuff going on.
Okay, so we're gonna have to reset you another time to give you time to get with the district attorney's office.
I also, filed, I don't know how to work the e-file thing very well at all. And the first motion to dismiss I filed, I don't know if I even sent it to the right people. So I refiled it, and then I think I put the wrong case number on it. So then I refiled it again, and I
Okay.
filed,
Okay,
a couple other motions, but,
Okay.
I think I have it right now. Is that Shane Hilton showing up on that e-serve thing?
okay, so we would have to set those motions for hearings, for a hearing.
Yes, sir. I filed a motion to request a hearing for that, and then I filed a,
Let me check out. You might have to go to the conference.
motion to continue and or abate revocation adjudication setting pending ruling on.
Hold on, let me see if let me see if they have the motion in
I don't see.
I see a motion over here. I see
see
a
a motion.
motion to dismiss, that's in cause number 25 CCCR 0594.
Yes, sir.
Also in the.
I think I finally got it right.
And you say you have it in the MTRP one?
Yes, sir.
Yeah, so we just have to set it for pretrial hearing. Okay, so
What day you want to be? Day of the week, right?
probably on a Thursday afternoon. We try to do it toward the end of the week because we have trials in the beginning of the week.
Thursday afternoon would be good now.
Yeah, it's okay. Let's find a Thursday. Let's give him about, what were you saying?
I was just asking him if Thursday afternoon was good with him.
That's this Thursday?
No.
Okay.
Hey, Thursday.
No, he had to get us.
Yeah.
State time, I mean, yeah, no,
But
we're
like, if
gonna
you
give you
work
30
Thursday
days.
afternoon, then that would be an issue, then we.
Well,
Are you saying like tomorrow?
yes, sir. I was like, well,
No,
No,
You need probation here for that.
I'm not gonna do that.
Hmm?
You need the probation officer here for that hearing. You said one of them.
that's up, it's up
Yeah.
to the state. He says, he's saying, yeah,
Yes.
Yes.
yeah, okay.
Okay, so does the state would notify the, is appeal or do?
No, I'll do that.
You'll do that, okay. We want it, what about February the 5th? I mean, how long will it be?
Standard 30,
Standard, okay.
yeah.
We got a bench trial on the 12th. We got a motion to suppress on the 19th.
We got
February
the-
26th
Is the 26th, okay, February 26th.
yes,
at 1:30.
Let's see. Yeah. February 26th,
You said 1:30.
1:30. 20,
Yes, sir.
26 and 1:30. Let's say motions here and motion to dismiss hearing.
Are you?
Okay, Mr. Kramer, you can get your recess. Once you get your recess, you're free to go. You have a blessed day.
thank you.
You are.
Go and have a meeting discussion.
Yes, you may be dismissed. You have a blessed day.
Thank you, sir.
You are.
Yeah, it's
I
not,
put Shane cut everything done.
yeah, that's
Something or another.
Robert. Uh, no, but, yeah,
Mr. Gilman,
But
did
so
you need
this
something?
thing is like,
Yeah,
I'm happy.
It's not great, it's a little, take a few minutes.
That makes it probably better.
Okay, you.
easy thing to do.
Thank you.
Have a seat, just a few minutes, okay, and I'll call you right back up.
Attorney Zamora, are you,
Yes, sir.
you ready on yours? Or do you need time to talk to the prosecutor? That's fine. Okay, all right. Order being recessed. Jefferson County Court of Law number 2 is in session. Court is in session in cause number 25 CCCR 1050. Case is style of state of Texas versus David Lynn Brandt. Mr. Brandt, is that your full name?
Yes, sir.
Mr. Brandt, would you please raise your right hand? Mr. Brandt, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Brandt, you may put your hand down. How are you doing, Mr. Brandt?
Good.
Yes, I'm doing fine, thanks for asking. Mr. Brandt, you're represented in your case by your attorney, Attorney James Padgett. Attorney Padgett, how are you doing?
I'm blessed. Good morning, Your Honor.
Yes. Good morning. Mr. Padgett, do you waive a record in Mr. Brandt's case?
Yes, Your Honor, we do waive the record.
Okay, Mr. Brandt, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Brandt, it alleges that you, David Lynn Brandt, on or about March 26th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury to a family member. Mr. Brandt, do you understand what you have been charged with? To this charge, how do you plead guilty, not guilty, or no contest?
Context.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Brandt, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on the line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there's one box checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification on paper. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Brandt, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Brandt, are you a citizen of the United States?
Yes, sir.
Take over State's Exhibit 1.
Any objection?
No objections to State's Exhibit.
No
1.
objection. States Exhibit number 1 will be admitted. Mr. Padgett, you have advised and counseled Mr. Brandt. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
And Mr. Brandt, your attorney, Mr. Padgett, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Brandt, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 270 days county jail, probated for a period of 15 months of community supervision, a fine of $150, repayment of court costs, 54 hours of community service, completion of the anger management class, and have no contact with Ron Brandt and Tiffany Stevens.
Yeah. Oh, yeah. Well, you should be here. Jones. No, no. His fellow kids was disposed of. And he was on the list. Is it the transport? What was he disposed of? Is nobody saying? This guy. Wait.
Oh,
This,
what's up? Listen. Yeah.
Oh, John. Ashley, you get it?
What's the court cost in Mr.
No, that's what it is.
277?
Oh, yeah.
Yeah, I have it. Thanks. Okay, Mr. Brandt. The state is offering that you serve 270 days in Jefferson County Jail, but you would not have to serve any time in the Jefferson County Jail because you'd be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $150 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, reimbursement fee of $15 a month, and well, your analysis fee of $15 a month and a reimbursement fee of $15. You will also be required to pay $100 to a crime victims program in Jefferson County. Your total monthly installments, that is the total amount that you will be required to pay in this case, is $119 a month. Will you be able to pay the $119 each month? You will also be required to perform 54 hours. Is that that's right, 54 hours of community service? You will also be required to attend and complete an anger management class. You cannot have any contact with Ron Brandt and Tiffany Stevens. You will also be required to adhere to the other standard terms and condition of this probation. Mr. Brandt, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Brandt, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Brandt, I need to give to your attorney a document that's titled Model Written Ammunition on Ineligibility to Possess Firearm or Ammunition, and I'm going to go over this document with you. Could you hand this to you?
Sure.
Right, okay. Now, Mr. Brandt, this document states that in accordance with Texas Administrative Code, Section 176.1, the court hereby admonish you of the following. Number one, you are, by entry of order or judgment, ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number 3, under Texas Penal Code Section 46.01, a firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is 1, an antique or curio firearm manufactured before 1899, or 2, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. For your reference, you may wish to consult the statutes listed below, which may or may not apply to your circumstances. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 27.14E1, plea of guilty or nolo contendere in a misdemeanor case. Code of Criminal Procedure, Article 42.0131, notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse, or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. And Family Code Section 85.026, warning on protective order. Now, Mr. Brandt, the model written ammunition that has been handed out to you is for your records. This will conclude your case. You're gonna stand at the end of the table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go, and you have a blessed day.
Thank you, Your Honor.
You're welcome, and you're free to go as well,
Thank you,
Mr.
Your Honor.
Patch.
Thank you, Mr.
Haley,
Yes, Your Honor.
how you doing?
I'm good. How are you, Judge?
I'm doing fine. I heard you here to address Amber Croft. We had it set for hearing at
Oh.
11 a.m.
That's correct.
Okay.
I just got word from Dustin. It turns out Miss Croft did have surgery and she's not able to make it to the courts today. So we were going to request a brief reset.
A
on that.
reset?
Yes, Your
Okay.
Honor.
Hold on a minute.
Say it again. In Spanish, on the tablet, I don't know, we have, well, maybe paper. We're gonna check.
We have what?
Stuff, paper, keep paper in Spanish.
I don't know. I don't think so, because the people, we just have, we have an interpreter who can, interpret for her.
Alright, so I guess that would be the hydrogen problems. I sure we're on.
Right, which you get,
Sorry.
yeah,
She should. I said,
Yeah.
should we? You got a problem? Me?
Miss Redmond,
Right now.
we need a reset on Croft.
Okay.
Will standard reset be sufficient, Haley?
Yes, Your Honor. Yes, Your
Okay.
Honor.
What, at 11 a.m. again is the time?
Yeah, we'll do it at 11 a.m. again, is that fine?
That would be
And we
perfect. Your
probably
Honor.
want to do it on a Thursday too, because it's probation officer. Yeah, I haven't done in February on
On the Thursday, that's what I'm checking. Yeah.
what's up?
We have a strong on the 12th, we have a motion to suppress on the 19th. Unless you want to do February, that's just last week.
No, she give us 30 days, she's, hold on a minute. Is the February 25th at 11, is that fine?
That would be perfect, Your Honor.
That's perfect, okay. So this case will be reset February 25th, 2026 at 11 a.m. Okay, and Miss Simmons will be sending your reset.
Okay. Thank you,
You-
Judge.
You're free to go and you have a blessed day.
You as well.
Okay. Who is your You can stand right there. Okay. You're Arlington Austin Wood?
Yes, sir.
Okay, Mr. Wood, how are you doing?
Good.
That's good. Now, Mr. Wood, your attorney, Mr. Kimler, was in a murder trial in Hardin County. And so he's unable to be here, so we will give you a reset. Stay in contact with your attorney and your bondsman, and you have a blessed day.
Thank you, Your Honor.
You're welcome. You can stand in front of the court coordinator for your reset. This is cause number 25 CCCR 2360, case of style of the state of Texas versus Da Vinci F. Reyes. Ms. Reyes, is that your full name?
Yes.
How are you doing?
Good.
I'm doing fine, thanks for asking. Ms. Reyes, you're represented by your attorney, Jennifer Delodge, and again, Ms. Delodge, how are you doing?
I'm great, Judge. I hope you are too.
I am, thanks for asking. Now, Ms. Delodge, what is your announcement in Ms. Reyes' case?
Judge, we'd like to apply for pretrial diversion and therefore we need some time to do so.
Okay, I think the next pretrial diversion is after February, it's gonna be in April.
That's what I was thinking.
So we're gonna reset it to the second week in April. Is that April the 13th? That's what you setting it to? Okay, this case will be reset to April 13th, 2026. Ms. Reyes, you're gonna get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day. And Mr. Lodge, once you get your reset, you're free to go as well, and you have a blessed day.
Thank you, Judge.
You're welcome.
Thank you.
Pretrial diversion. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24 CCCR 2906. Case is styled the state of Texas versus Jose Jesus De Leon. Mr. De Leon, is that your full name?
Sir.
Mr. De Leon, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. De Leon, you may put your hand down. How are you doing, Mr. De Leon?
How are you?
You doing good? That's good. I'm doing fine. Thanks for asking. Mr. De Leon, you're represented in your case by your attorney, Attorney Trinidad Zamora. And Attorney Zamora, how are you doing?
I'm well, thank you.
Okay, now, Mr. Zamora, do you waive a record in Mr. De Leon's case?
Yes, we do.
Okay, Mr. De Leon, I have before me on my computer a document that is titled Information. In this information, it alleges that you, Jose Jesus De Leon, on or about August 9th of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense.
Your Honor, the state's going to move to abandon the enhancement paragraph.
Okay. Now, Mr. Zamora, the state is abandoning the enhancement paragraph. And what that means is, instead of being charged with a Class A misdemeanor offense, you'll be charged with a lesser included Class B misdemeanor offense, DWI. Do you understand that?
Mm-hmm.
Now, to the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about August 9th of 2024, while you were operating a motor vehicle in a public place, how do you plead? Guilty, not guilty, or no contest?
Guilty, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Okay, now, Mr. De Leon, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of this same document, there are a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there's one box checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The next document that I have is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. De Leon, before you signed and initialed these documents, did your attorney go over these documents with you? Did you understand everything that your attorney went over? And we had Ms. Jennifer Raji, who is our Spanish interpreter. She also went over part of this document with you to explain to you a term that you didn't understand in Spanish. Is that correct?
Yes.
All right. Now, Mr. De Leon, did you understand everything that Attorney Zamora went over and Mr. Raji? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Are you a citizen of the United States?
That overstates Exhibit 1.
Any objections?
No objection.
No objections. State's Exhibit number 1 will be admitted. Attorney Zamora, you have advised and counseled Mr. De Leon. Is there any evidence that he is currently mentally incompetent to stand trial.
But he is competent.
Okay. And Mr. De Leon, your attorney, Mr. Zamora, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yeah.
Mr. Mr. De Leon, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication, a fine of $500 with repayment of court costs. The state has agreed to waive the community service hours, but as for the requirement of the interlock and the standard DWI terms and conditions for a first offense, and as the state has already agreed to abandon the enhancement.
Okay. What's the court cost?
$392.
Way, he's already had this, this interlock for a minute, so is there a way that we can address at 6 months, potentially removing that requirement, or?
Was that part of the plea bargain agreement?
No, I'm just asking if there's any of that happening for consideration of early termination.
Well, you can't have an early termination on a,
I'm working on them.
I'm just talking about the condition of the interlock, that's all I'm asking.
I understand. If it's,
15 months, there's not been one issue, that's why I'm.
understand, but if it's, if that was part of the, plea bargain agreement, the court will consider that, but if it's not part of the plea bargain agreement.
Talk to the state. He mentioned something about not opposing if I was to submit a motion to address that at that point. There's no issue.
So are you, what he's saying is, instead of having the interlock device for the full length of the probationary period, they're requesting that it be only for 6 months of the probationary period, half of the probationary period.
I think it's saying that if there's no incident at the 6 month period, and I said that I didn't agree to that, but I said that I think for deferred adjudication, there's a statutory period. I don't know if it's halfway or it's 2/3 where they can, if they're successful and have done everything on their probation, then they can file for early termination. And I said, I don't see anything that would.
I mean, you're saying that, what you're talking about at that point, you're saying that if 6 months into his probation, if he has not had any problems with the probation, you don't see any problem. But right now we haven't got to that bridge. We'll cross that bridge when and if we get to it.
Right.
So the court can't make a ruling beforehand.
I understand.
And so, but I mean, you can make your motion. You can file your motion at that point. Okay.
I don't know if he's asking what our court policies and procedures.
Well, we don't
are
have,
for that, or-
we have hearings. And then we'll,
Understand.
make a ruling at that time.
Thank you.
Okay, now, how many hours? No, okay, you was waiving the community services,
Yes, I
right?
did agree as part of plea officer to waive the community service.
Okay. Let's see, this is, t- s- this is your court.
Which one?
What y'all, we on the,
No, they go next door.
we on Zoom.
Oh, she said next door.
Okay, let's see, we're abandoning enhancement paragraph. Oh. So we do that in. Okay. Mr. De Leon, the state is offering that you serve 12 months or 1 year deferred adjudicated probation. During the 12-month deferred probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You will also be required to pay a DWI conviction fine fee of $100. You will be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $182 a month. Will you be able to pay the $182 a month? You will also be required, well, you will not be required to perform any community service because that is being waived. You'll be required to install an interlock device on any vehicle that you own and operate. I understand that you already have one. You will be required to attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Now, Mr. De Leon, do you understand the state's offer? And do you accept the state's offer? Mr. De Leon, I will follow the plea bargaining agreement that you have entered into with the state. Now, Mr. De Leon, if you successfully complete this probationary period, this case will not result in a conviction on your record, and you may qualify for what is called a non-disclosure, whereby your record is sealed to the general public. You can talk to your Attorney Zamora, about the non-disclosure because he's quite competent in those matters. Now, Mr. De Leon, this will conclude your case. I will follow the plea bargaining agreement. You're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. And Attorney Zamora, you're free to go as well, and you have a blessed day. Okay, you're welcome. Court is in session in two cases. Both cases are style of State of Texas versus Artest D. Kane. Mr. Kane, is that your full name? How are you doing, Mr. Kane? That's good. And Mr. Kane, you represented in your cases by your attorney, Attorney David Grove. Mr. Grove, how are you doing?
Good, Judge, thank you.
That's good. And Mr. Grove, would you please state to the court what your announcement is?
Yes, sir, Judge. I've discussed the two cases with Mr. Kane, and Mr. Kane wants to turn down the plea bargain offer in both cases and set both cases for trial.
Okay, give us a trial date. Give us about 45 on these because I know we have some other ones.
Okay.
That's some older cases.
You wanna do the March 16th?
March 16th, okay. These cases will be reset for trial on March 16th, 2026. And Mr. Kane, you will get your resets from our court coordinator. Once you get your resets, you're free to go. And you have a blessed day. And Mr. Grove, once you get your resets, you're free to go as well. And you have a blessed day.
Thank you, Judge.
You're welcome. Okay.
Jones.
Session cause number 25 CCCR 3047, cause number 26 CCCR 0131, cause number 25 CCCR 2274. All three cases, excuse me, not 74, it's cause number 25 CCCR 3046. All three cases are styled the state of Texas versus Paul Dylan Jones. And Mr. Jones, is that your full name?
Yes, sir.
Mr. Jones, would you please raise your right hand? Mr. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Mr. Jones, you may put your hand down. How are you doing, Mr. Jones? How are you doing?
Wonderful.
Wonderful, that's good. Now, Mr. Jones, you're represented in your cases by your attorney, Attorney Todd LeBlanc. Attorney LeBlanc, how are you doing?
Good, Judge.
And Mr. LeBlanc, do you waive a record in Mr. Jones' cases?
We do, Your Honor.
Mr. Jones, in cause number 26 CCCR 0131, I have before me a motion, I have before me an information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Paul Dylan Jones, on or about September 29th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Mr. Jones, do you understand what you have been charged with?
Sir, I do.
And to this charge, how do you plead guilty, not guilty, and no contest?
Guilty.
Guilty? Let's see, paperwork. On the paperwork, it says no contest.
I'm sorry, Judge, yeah.
Now, you pleaded no contest freely and voluntarily?
I am.
And are you pleading no contest because you do not wish to fight or contest the charges?
I am.
Now, Mr. Jones, I have before me a document that is titled Misdemeanor Plea. My instance, this document is also labeled as State's Exhibit Number 1. You recognize this document? You do? On page 2 of this same document, there's a set of initials on a line next to a box that's checked no contingent, which means no contest. You place your initials on this document. On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I do.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Mr. Jones, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you understand everything that he went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Jones, are you a citizen of the United States?
Yes. State offers State's Exhibit 1.
Any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. And Mr. LeBlanc, you have advised and counseled Mr. Jones. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of.
Mr. Jones, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
I am.
Has he provided fully effective and competent legal representation? Mr. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 114 days county jail with credit for time served of 114 days, and ask that the court costs in this matter be taxed and retired. And this is concurrent with cause number 25 CCCR 3046. And the state agrees to dismiss cause number 25 CCCR 3047.
Okay. Mr. Jones, the state is offering that you serve 114 days in the Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail because you've already served 114 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And this case will run concurrent with cause number 25 CCCR 3046. And the state will be dismissing cause number 25 CCCR 3047. Mr. Jones, do you understand the state's offer?
Yes, I do.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Jones, I'll follow the plea bargain agreement that you have made with the state. Okay, Mr. Jones, we move to your next case. Your next case is cause number 25 CCCR 3046. And in this case, I have before me an information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Jones, it alleges that you, Paul Jones, on or about September 14th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Jones, do you understand what you have been charged with?
I do.
To this charge, Mr. Jones, how do you plead? Guilty, not guilty, or no contest?
No.
No contest? Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Jones, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. And do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked nolo contendere. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box says check, states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendants? Now, Mr. Jones, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Any objections to State's 1?
No objection.
No objections. State's Exhibit Number 1 will be admitted. And Mr. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 114 days county jail with credit for time served of 114 days. And ask that the court costs in this matter be taxed and retired. And this case is run concurrent with cause number 26 CCCR 0131. And the state agrees to dismiss cause number 25 CCCR 3047.
Okay, Mr. Jones. The state is offering that you serve 114 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 114 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. This case will run concurrent with your companion case, cause number 25 CCCR 0131, and the state will dismiss cause number 25 CCCR 3047. And Mr. Jones, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Mr. Jones, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Jones, you're gonna stand at the end of that table, follow the direction of the bailiff.
Yes, sir.
Once you finish following the directions of the bailiff, you can follow the bailiff and you have a blessed day.
Thank you so much.
You're welcome. Okay, this side is dismissal. Okay. You ready on Linda?
Yes, Judge.
Okay. Next case is cause number 25 CCCR 2274. Case is styled the state of Texas versus Reginald Linden. Mr. Linden, you may come forward. And Mr. Linden, how are you doing?
I could be better, Judge.
Okay. Now, Mr. Linden, you're represented in your case by your attorney, Todd LeBlanc. Mr. LeBlanc, what is your announcement in Mr. Linden's case?
Judge, I attempted to convey the offer to him. He's rejecting the
Okay.
offer. So we need to set it for trial.
Okay, that's fine. Give us a trial date.
Judge, may I speak, please?
Okay.
I think he's unhappy with me, Judge, because he thinks something's supposed to have already been done by now. So if the court wants to address it, I've tried.
I mean,
to tell him.
normally if there's some issues with the attorneys, you're well aware that there's motion that can be filed. I mean, if there's a conflict between you and your attorney can file a motion withdrawal. But so the court is not in a position to entertain that without having a motion before it. Okay?
I just wanted to bring things to light and lead up to that, Judge.
Okay, well, at this time, I mean, if it's gonna be a motion to withdraw that's gonna be filed, we can reset your case. What I'm gonna do, I'm gonna put it on a pretrial conference docket. And then if we get a motion, then we could entertain that at that time, okay?
Well, Judge, he hadn't asked me to file one. That's what I'm gathering because he thinks I'm supposed to already have gotten this case dismissed prior to.
Oh, well,
That is not true, Judge.
well, let me now, Mr. LeBlanc and Mr. Linden. The court is not here in a position to settle any disputes that you, the attorney and the client may have at this time. As I mentioned to you earlier, we can handle that if a motion is before the court. Okay? So at this time, I'll just reset it this case for pretrial conference in anticipation that a motion is forthcoming. All right?
And I do anticipate that it needs to go on the trial docket.
Okay, yeah, but
That's good.
we'll cross that bridge when we get to it.
Okay.
So at this time, let's set it for on the pretrial conference docket. Okay, that's fine. This case will be reset to February 23rd pretrial conference docket. And so you can get your reset. Once you get your reset, you're free to go. You have a blessed day. And Mr. LeBlanc, you have a blessed day as well.
Thank you, Judge.
Okay,
Mr. Cole is on this one.
okay. Okay, you can stand in front of the court coordinator. She'll give you a reset. And if you file a motion, make sure you give a copy to Mr. Linden. Okay,
Here you go, Mr. You're welcome. Okay. This one going to have your copy. If we want.
okay, this is cause number 25 CCCR 2304, case of style the state of Texas versus David Samuel Worsham. Mr. Worsham, would you please come forward? Okay, Mr. Worsham, how are you doing?
I'm doing fine, sir.
That's good, Mr. Worsham. You're represented by your attorney, Attorney Giles Cole. Mr. Cole is currently on Zoom. And Mr. Cole, how are you doing?
I'm doing good, John. I just pulled over. I was en route. I'm still about 20 minutes out.
Oh,
But I haven't had a chance to get with Mr. Worsham, so I don't know how you want to
I
go
mean,
about doing it.
obviously, I mean, if you're saying that you hadn't had a chance to get with Mr. Worsham, I don't think anything will be, you'll be able to do anything in terms of resolving his case today because you have to meet with your client. And
That's right.
I'm sure you have discovery. And so what we'll do, we can reset the case to give you an opportunity, Mr. Worsham, to meet with your attorney. And also your attorney has to get discovery, negotiate on your behalf, and then get back with you. Okay, and also do an investigation. Okay, so this case is going to be reset. Give us a reset date.
February 23rd.
Okay, this case will be reset to February 23rd at 9 a.m. And Mr. Worsham, you get your reset from the court coordinator. Once you get your reset, you're free to go. You have a blessed day.
Thank you.
You're welcome. You can stand in front of the
Your
court.
Honor,
Yes.
Your Honor, could I give
Mr.
Mr. Worsham my contact number, my information, my cell phone number, so he
Okay,
can call me?
Okay, hold on a minute
I have
until he wants to give you his cell number. Hold on a minute.
all righty.
Okay, you can go.
Okay. The area code is 409-678-8646.
8646.
That's right, sir.
Okay.
And if you give me a text message,
Yeah, he's saying he's calling it right now.
I got him. I see it.
Okay.
I got it.
All right, thanks a lot.
All right.
Okay, you can
Thank
get your
you.
reset. Once you get your reset, you're free to go stay in contact with your attorney
Yes.
and your bondsman. And
Yes.
you have a blessed day.
Thank you.
All right, you're welcome. Okay. Oh. Is
Maybe excuse your Honor.
yes, Mr. Cole, you're excused and you have a blessed day.
You do the same. Thank
All
you.
right, thank you. And this will conclude the calling of the court's announcement docket, motion to revoke probation docket, both dockets scheduled on January 28th of 2026 in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Mr. Hilton, you're free to go,
Thank you, Your Honor.
and you have a blessed day.
Thank you, you too.
Okay, and everyone, please have a blessed day.